Judge with the Office of Administrative Hearings. I've been assigned to preside over this hearing. First, to ensure there's a quorum, I'd like to have each of the panel members identify themselves for the record, starting with the panel member to my furthest right.
Dave Garner.
Christina Lawson.
Michelle Bolott.
Howard Kraus.
Denise Pines. Brenda Sutton-Wilson.
All right, there being a quorum, I would like to take the appearance of counsel for the parties, starting with the Deputy Attorney General.
Good morning, Your Honor and members. E.A. Jones III, Supervising Deputy Attorney General on behalf of the complainant.
Good morning.
Good morning, Your Honor and board members. Lindsay Johnson on behalf of Respondent Jasper Tawana, who is present and seated to my left.
Good morning. All right, the board in this matter has issued an order of non-adoption of a proposed decision by an administrative law judge and has decided to determine the matter itself. The board has invited discussion of whether the proposed order should be modified. The following time limits will apply strictly. The respondent will have 15 minutes to make opening argument. The Deputy Attorney General will have 15 minutes for a response. Respondent may take 5 minutes for closing argument, and the Deputy Attorney General may also take 5 minutes. The arguments must be based only on the existing record in this matter. They shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. At the end of oral arguments by counsel, I may offer respondent physician an opportunity to directly address the panel regarding the penalty. If respondent chooses to do so, I'll swear him in. After oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will be receiving it in the mail sometime in the future. Again, I reiterate, base all your arguments only on the existing record. Please don't bring in any new evidence, and assume that the board has already read your briefs. All right. Ms. Johnson.
Thank you. As this board is well aware, Dr. Tawana was licensed by the state of California in 2008 as a physician. Over the last 9 years, he has established a thriving and professional career. Working as a hospitalist, he currently serves as the chairman of medicine and has been supported unwaveringly by his colleagues, his friends, and perhaps most importantly, his patients. Nominated multiple times as Physician of the Year, his colleagues have issued no concern over substance abuse and support his licensure and his continued licensure without any restrictions. We're here today because Dr. Tawana has a single sole misdemeanor conviction for driving under the influence. Over 3 years ago, in March of 2014, Dr. Tawana, after finishing a shift, joined his family at his sister-in-law's house, where he consumed 2 rather large glasses of wine. As he had arrived separately from his wife and children, he drove home separately, on the way glancing at his phone to see if he had any missed messages, swerving, and subsequently being pulled over. After being pulled over, Dr. Tawana, according to the police officer in the report, was cooperative. Although he initially tried to minimize his actions that night, he almost immediately accepted responsibility. He was tested for alcohol and received a blood alcohol content report of 0.11. He was subsequently arrested, and in November of 2014, pled guilty, taking full responsibility in criminal court for his actions. He was sentenced to probation, a first offender's DUI class, and various fines and fees. He completed that class within a month, and subsequently has resolved his criminal matter almost completely. This was the first time Dr. Tawana took responsibility for his actions, but it was not the last. He immediately disclosed his arrest to the medical board and then sat through an interview with the investigator where he was open, cooperative, frank, and accepted responsibility. He then continued that path in front of an administrative hearing, where in November of 2016, Dr. Tawana appeared at that administrative hearing and once again accepted responsibility for his actions. Additionally, though, at that time, providing hopefully this board with reassurance of his rehabilitation and his assurance that it would never happen again. This testimony was supported not only by Dr. Tawana's frank and candid testimony, but additionally by the testimony of 3 other witnesses who testified on his behalf. His wife, who testified as to his social perception and how he handles himself following the DUI in social situations. As someone who was around him the most when not at work, his wife was able to testify as to the fact that Dr. Tawana no longer drinks. This testimony was also supported by the professional realm, by a colleague who testified on Dr. Tawana's behalf, not only to his skills as an excellent physician, but also to the fact that there is no concern in the workplace, according to this colleague, that Dr. Tawana suffers from any substance abuse concerns. The colleague also testified as to the on-call system and how that works at Dr. Tawana's facility, a concern singled out by the board at the hearing. The night of Dr. Tawana's DUI, he was technically on call that night, and that obviously raised a concern for the board, as it raised a concern for Dr. Tawana when he testified at hearing. But it was important to note how the on-call system worked at that facility. It was done through an app on the smartphone, which allowed various physicians who were on call that night, not just Dr. Tawana, to simply push the call to another physician if they did not feel able to take it. Doctors routinely apparently used it at the facility, allowing the call to be pushed if they wanted to go to a movie, join their family for an event, or in Dr. Tawana's case, go out and have a family gathering that night. This did not raise a concern that Dr. Tawana would return to the hospital that night in any way impaired and to threaten or in any way endanger patients. And then, perhaps most importantly, outside of Dr. Tawana's testimony, there was a third witness there on his behalf, Dr. Richard Sander, a board-certified psychiatrist with a subspecialty in addiction, who was singled out by the administrative law judge as very well known and highly respected in his field. Dr. Sandar testified to the comprehensive evaluation he conducted on Dr. Tawana, which not only included an interview of Dr. Tawana, but a review of all the documents in this case, a review of Dr. Tawana's cures report, and a review of Dr. Tawana's labs reports, which allowed him to look at enzyme levels and determine whether or not there was any concern of substance abuse. Dr. Sandar concluded that there was not, and that Dr. Tawana not only did he not present as a candidate for substance abuse, but more importantly that recidivism was highly unlikely. As a result, the administrative law judge following the hearing issued a proposed decision. In that proposed decision, the administrative law judge singled out that, and I quote, respondent's conviction is an anomaly in his otherwise law-abiding life, and his commitment to continued abstinence suggests that recidivism is highly unlikely. Aside from the single misdemeanor conviction, complainant presented no evidence of any impediments to respondent's ability to safely practice medicine in a proper and safe manner. As a result, the administrative law judge determined that the proper punishment in this matter would be a reprimand. As he said, other circumstances are unnecessary, and a public reprimand will best protect the public without imposing overly harsh and punitive discipline on respondent. That decision, as we all know, was not adopted, and that's why we're here today. However, it's respondent's contention that that decision was well-reasoned and should, in fact, in this matter, be adopted. The board here is put in a unique circumstance where you are asked to decide the outcome of this case without the added benefit of having the witness's testimony lying in front of you. Although certainly you have the transcripts and you have the multiple exhibits that respondent presented at hearing, which included 9 different documents, contrary to the argument raised in complainant's brief that he only presented evidence of his probation compliance. In fact, he presented evidence of his awards, of letters from various colleagues, including his chief of staff. And also he presented this testimony, which is very important. Recognizing the board's situation and having to decide this matter separate from the hearing, we're fortunate in the fact that the regulations and case law has given us guidelines to kind of help cure the board's actions in this matter. As we all know, the purpose of these matters are not to punish the practitioner. The case law has told us over and over again that that has seemingly been decided by the criminal court. Instead, the purpose is to determine whether or not the practitioner is safe to continue practicing, or whether he needs additional oversight by the board. In order to determine this, we need to look no further than the board's own published disciplinary guidelines, which have allowed us to put forth a series of criteria over whether or not the person is rehabilitated and thus safe. Under Title 16 of the California Code of Regulations, Section 1360.1, the board has outlined this criteria, and it's respondent's position that Dr. Tawana has met that criteria, and therefore does not need additional oversight. Starting with subsection A, the nature and severity of the actions. No one, including Dr. Tawana himself, is asserting that his actions that night were in any way correct. He has taken full responsibility of those actions. And yet, he has also presented ample evidence that they were not only an anomaly, but they will not be repeated, that they were not indicative of a problem, and his testimony was frank and cooperative. I'm sure many people have come before this board and stated that they are a unique case, and Dr. Tawana is probably not the first person to do so. But I think that his case does represent a uniqueness in the sense that he is probably one of the first times that Complainants Counsel has singled him out for his cooperation. In closing arguments at the administrative hearing, Complainants Counsel stated, "Respondent is remarkably well educated, very accomplished physician, and I have not said that about probably anyone I've ever had the fortune of prosecuting since I've been in the Health Quality Enforcement section of the AG's office. I think he's one of the few witnesses I've ever examined in a long career as a prosecutor who has been willing to really step up to the plate and take responsibility and answer honestly the questions that I posed to him." This is indicative of who Dr. Tawana is, and it is shown not only to those who know him personally, but those who have seen firsthand his acceptance of responsibility. Moving to the second subsection of rehabilitation, the total criminal record. This matter consists of Dr. Tawana's entire criminal record, and it has been fully resolved. He was arrested more than 3 years ago, so the time elapsed has been 3 years under subsection C, and he has complied fully with his criminal matter under subsection D. But perhaps most importantly is subsection F, his evidence of rehabilitation. Not only do those who know Dr. Tawana assert that he no longer drinks, not only does Dr. Tawana assert that he no longer drinks, but the board has the added benefit and reassurance from an expert in this matter who has done a comprehensive and thorough evaluation of Dr. Tawana, who also concludes that his recidivism is unlikely, and that Dr. Sandar is remarkably confident that this will not be repeated. That layer of extra reassurance to the board should provide them with the ability to not only see that Dr. Tawana is no more likely to reoffend than any other physician who appears either before this board or holds a license from the state having to not appear before this board, but it also provides the extra level of reassurance that Dr. Tawana has taken this matter seriously and has put forth the best effort to provide any extra reassurance and to quell the board's concerns. The complainant in their non-adoption brief has raised the idea that Dr. Tawana should be set with 4 years of probation, along with various testing terms. As I mentioned earlier, it's respondent's position that since the purpose of these proceedings is not to punish the practitioner, but to protect the public, that 4 years of invasive testing of Dr. Tawana will not only punish Dr. Tawana in a way that is not congruent to the action, but additionally will not help the public. There has been no evidence put forward that Dr. Tawana will reoffend, and the idea that he should be tested for 4 years under pure speculation is not supported by case law. Instead, there must be some sort of logical conclusion done by factual findings, and those simply don't exist in this matter. In fact, all factual findings are to the contrary. The idea that Dr. Sandar could not say with 100% certainty that Dr. Tawana would not reoffend is actually not a negative to Dr. Tawana. Any medical provider, just as any lawyer, cannot 100% guarantee anything. And so the fact that Dr. Sandar would not stand on this stand, or sit on this stand, and say that I 100% guarantee that Dr. Tawana will not reoffend, if anything, gives more credibility to Dr. Sandar and to his findings. It's important, though, to note his actual finding, which is, and I quote, "I am very comfortable based on my 30-something years, 25 years working with alcoholics and addicts and knowing the problem. I do not believe that this man is going to develop more alcohol-related problems in the future. I feel very confident about that." And because of this, we see this extra layer, that Dr. Tawana not only will not reoffend in the future based by everyone who has reviewed him, but additionally that 4 years of additional testing will only prove as punitive if it's done purely on the idea of speculation. Essentially, the board is asking that a treatment and a program be imposed on Dr. Tawana with serious side effects with no actual diagnosis. And that's a dangerous proposition to not only licensees, but to the ideals of the board and to the public itself. The public, because they will not be harmed by Dr. Tawana's continued licensure, we also must look at the fact that the public will be harmed if Dr. Tawana is placed on probation, especially for 4 years with extensive testing terms. Not only will this cause Dr. Tawana to have to leave the hospital for various shifts in order to testify, but even more importantly, probation triggers a concern of exclusion from the Medi-Cal and Medicare list, as well as an automatic reduction of the Blue Cross Blue Shield's privileges.
Counsel, 3 more minutes.
Thank you. Blue Shield's privileges. As a result, as noted by the administrative law judge at the hearing, Dr. Tawana's ability to practice and his ability to serve the patients will almost be rendered useless. He will, if facing exclusion from the Office of the Inspector General and the Department of Health, as well as from Blue Cross Blue Shields, not be able to treat many patients in California. And as for someone who both sides agrees is such a skilled practitioner, that is truly a loss to the public. And we have to look at whether or not this loss to the public is in some way outweighed by the idea that for 4 years, someone with a single misdemeanor with a relatively low blood alcohol level should therefore be subject to testing. The board has set forth their substance abuse guidelines, and we certainly recognize them. But it's equally important to recognize that the law setting forth that guideline, Section 1361, subsection A, in the very introduction of it, allows the board the ability to deviate from those if they feel that there's mitigation and rehabilitation that warrants it. And the mitigation and rehabilitation in this case simply exists. It exists not only through the testimony, and it exists not only through the reports, but it exists through the documents that were also presented on Dr. Tawana's behalf. His Physician of the Year notifications and nominations, his patient compliments, the letters from his colleagues who point out his successes, the testimony from Dr. Tawana, the testimony from his wife, the testimony from the expert who has reviewed him. And looking at all of these conclusively, we see why the administrative law judge and why this board is offered the opportunity of a reprimand. The government code makes it very clear. Revocation, probation, reprimand, and then dismissal. The actions are all obviously on the table for a physician. And it's also why we see that this board recently has, in various other cases, also looked and issued reprimands for various blood alcohol levels. It's certainly a tool that the board can utilize. Ultimately, we ask this board to consider Dr. Tawana's case individually, to look at his character, his demeanor, his evaluations, his reputation, his rehabilitation, and adopt what we believe is well-reasoned decision from the administrative law judge in this case. Thank you.
Thank you, Ms. Johnson. Mr. Jones?
Thank you. Counsel for respondent has done essentially what the ALJ did, glossed over a serious consideration, a serious matter in this case. The ALJ found that there was a cause for discipline based on the conviction under 2236 of the Business and Professions Code, and also found that there was cause for discipline under 2239 in that respondent used alcohol to an extent or in a manner dangerous to himself, another person, or the public. What the ALJ did not address, or addressed only in passing, was the issue of on-call status. The record establishes that between 8 p.m. and 8 a.m. On the 15th of March through the 16th of March, the respondent was on call. He was the single on-call physician for that weekend period of time. The record also shows that what exactly was meant by being on call in his practice. You'll find in the supplementary investigation report an interview of Dr. Graham, who respondent testified was his mentor. And Dr. Graham advised, and this basically is administrative hearsay, which supplements or explains the respondent's testimony that he was on call. So this explains what on call was, and therefore is admissible evidence to that effect. But Dr. Graham indicated that on call means that the doctor is required to give orders to nurses regarding patients in the hospital. Nurses generally won't be calling the on-call physician unless they have a significant question. The doctor might be required to drive into the hospital if a person is being admitted from the ER and the doctor doesn't think the person should be admitted. The doctor would have to do a personal exam of the patient, so drive in. And there are other circumstances where the on-call physician might have to drive into the hospital. So being on call is a significant thing. Now, the ALJ essentially said that respondent testified. He essentially looked at respondent's testimony at the hearing and said respondent testified that he would, of course, push the call. Well, let us examine the circumstances at that time, and I think the circumstances suggest otherwise, or suggest that there is not really a sound basis for the ALJ to make that conclusion, nor for respondent's counsel to suggest that the doctor would have pushed the call. Because what we're talking about is the exercise of judgment, and we know that on that day, respondent first off exercised judgment in a very poor manner by deciding to drink while he was on call. He then further exercised poor judgment by deciding to drive while he was impaired. Now, there's no question that he was impaired. His own expert testified that he was moderately impaired and should not have been driving, that he was moderately impaired and should not have undertaken to perform any medical services such as evaluating a patient or making any judgment with regard to a patient circumstance. So he's impaired, he's driving. According to respondent's own testimony, he further engaged in poor judgment in trying to check his phone while he's driving on the freeway. So given that series of poor judgments, and given that he was impaired during the course of that time, are we to assume that he would have pushed the call? Or can we not say that it's more likely that, given his impaired judgment, he might have said, well, I can probably handle this call. I'm the only one on call at the moment. Everybody else is busy doing whatever. So I'll go ahead and take this call. So for the judge to assume and to make a finding based on the testimony of the doctor at the time when he was sober in the testimony at the hearing, to assume that that would actually reflect what the state of mind was of the doctor at the time when he was driving impaired, I think is a bit much. So I think there's a real issue here that involves the on-call status and the fact that he chose to drink, went on call, chose to drive. All of those reflect poor judgment. All of those are actions taken when he was impaired. So to assume that he would have pushed the call, I believe goes beyond what the evidence suggests. I think the inference is that there was a very real risk that he would have taken whatever call came his way and attempted to deal with medical issues while impaired. So that is a key factor here in assessing the facts of this case and determining what the appropriate remedy should be. I believe the ALJ's decision and recommendation for a reprimand is the floor for discipline in this case. This is not a case that should be dismissed outright. To do that would send the wrong signal to doctors throughout the state. That would suggest that they have a free opportunity to engage in the type of conduct that was engaged in this case without repercussions from the medical board. That obviously would send a bad signal to the public. The public would not have appropriate faith in the operations of the medical board if it were to outright dismiss this case. So the question is, as I indicated, what is the appropriate remedy? One option would be to adopt the ALJ's decision as argued by counsel. However, I don't think that would address appropriately the issues involved in this case, particularly the on-call status that was abused by the respondent in this case. So I believe that it would be in the public's interest that the respondent be on probation for a period of time. Now, as was pointed out, the board can deviate from the various guidelines, including the uniform standards where the facts indicate that is appropriate. Here you have on the record the evaluation conducted by respondent's expert indicating that he did not believe that that the respondent was a substance abusing physician and thought it unlikely he would reoffend. Well, that is all well and good, and I think that evaluation probably could substitute for the uniform standard which requires that an individual undergo an evaluation as a preliminary matter when the uniform standards are put into play. So with that, having that element of the uniform standards having been complied with, I think it would only be sufficient in this case that a period of time for the doctor to have biological fluid testing ongoing, to have an on-site worksite monitor, to attend AA meetings and that sort of thing would be appropriate for a period of time, so that the public would be assured that the testimony of respondent that this is a single anomalous incident, the testimony of the expert that the doctor not likely to reoffend, that those could be corroborated by a period of time on probation where he is subject to testing and to other reinforcing elements as provided by the uniform standards. Now, it was argued by counsel for respondent that the doctor is rehabilitated and engaged in sufficient rehabilitative efforts so that no further more discipline is appropriate. However, I think when you look at the rehabilitation evidence, I think all it establishes that he complied with the criminal probation that he was on. I think in most cases where physicians want to assure the board of their rehabilitation, they take further independent efforts to go above and beyond what they are mandated to do by the criminal court system, and that has not happened in this case. For example, there's no evidence that the respondent sought therapy to address these issues, or that he participated in any AA meetings on his own. So to suggest that he's fully rehabilitated, I think does not reflect the true nature of the record here. So, in conclusion, I think the record, given the conviction, given the abuse of alcohol, and given the fact that he was on call when all of this occurred, calls for more public protection than is reflected solely in a public reprimand. And a period of probation with the limited uniform standard conditions that I referenced would be the necessary elements to provide public protection in this matter.
Thank you, Mr. Jones. Ms. Johnson, 5 minutes.
Thank you. Just to briefly touch upon the points that were raised by complainant's counsel in this matter, starting, of course, with the on-call issue, which we all recognize as a matter in this case. It's something that Dr. Tawana recognized in his administrative hearing. It's something he testified to. Complainant's counsel points to the administrative hearsay document of Dr. Graham, who was interviewed, essentially, during the investigation. Respondent, though, however, would like to point to the direct testimony of the physician who testified at the hearing itself, Dr., and I'm going to actually spell it so I don't butcher it, which is Bagheri, who testified extensively as to the app that was used by the hospital and the Perfect Serve app specifically. When discussing this app, he was asked whether or not there was an informal arrangement among doctors to simply push the calls to each other, and he asserted that yes, it was. He was asked directly if you wanted to give a call to another doctor in the group with Perfect Serve, how would you do that? And then he explained that they had a toggle switch that you basically would take yourself off, and you could put a replacement for your calls to be forwarded to. As a result, there was, by all accounts, the ability for Dr. Tawana to not take calls that night, despite technically being on call, as several other physicians were available for him simply to toggle the calls to. And while complainant's counsel suggests that circumstances suggest, or the inference is, basically there were lots of words based on speculation. And the speculation from complainant's counsel is that Dr. Tawana would not simply push the calls. Yet everyone who testified on Dr. Tawana's behalf, not just Dr. Tawana himself, testified to his professionalism, his dedication, his safety, and essentially over and over again their reassurance that everything they know about Dr. Tawana indicates that he, by all accounts, would not only be honest, but safe. And we see that supplemented by his police report, which describes him as cooperative and able to basically essentially follow the directions there. If we're looking for inferences, although certainly speculation is not a factual finding basis, the inferences do suggest that Dr. Tawana, as he always has been, would remain a safe and dedicated practitioner that night, and that his ability to simply toggle the switch and send these calls to another physician is partially possibly the reason why, to borrow complainant's counsel's language, the administrative law judge glossed over the issue, because the evidence there supported the fact that this was actually not as large of an issue in the matter. Moving to respondent's second concern, that it is sufficient and almost necessary for Dr. Tawana to have biological fluid testing. It's interesting because that directly followed his argument that the reason Dr. Tawana deserves punishment is that he essentially exercised poor judgment. But there's no nexus or logical connection between exercising poor judgment and having to be a substance abuser, thus necessitating biological tests. Essentially, the board, or not the board, but complainant's counsel is asking that Dr. Tawana submit to biological testing because of exercising poor judgment, to borrow from their language, for an on-call issue. And that does not directly connect to the idea of whether or not the board thinks Dr. Tawana is a substance abuser, which is when the exercise of biological testing and probation terms should be imposed, if there's a concern that he is a substance abuser. And in this case, all evidence points to the fact that he is not. In fact, the evidence in this matter is important. Dr. Tawana did not just represent rehabilitation evidence of his compliance with criminal probation, although certainly he presented that, and that is important, because it included 3 months of alcohol testing, and it included regular AA meetings that were required by criminal court, thus providing that he did attend classes and he did attend AA meetings. But in addition, he presented other rehabilitation evidence. He presented an evaluation that he voluntarily underwent, which is not something every physician does. He presented letters from various colleagues who know him, including his chief of staff, who discussed their oversight over Dr. Tawana since learning of the incident and since his frank and honest disclosures to them about the incident. And he presented patient comments. Taken collectively, this rehabilitation is more than just his criminal compliance, but it shows the picture of who Dr. Tawana is. And it's this picture, once again, that we ask this board to consider when we look towards the reasoned and well-reasoned proposed decision issued by the administrative law judge in this matter, showing that Dr. Tawana is not a danger, that he's rehabilitated, and that testing terms for something that everyone concludes does not actually exist, a substance abuse disorder, is unnecessary and essentially punitive to Dr. Tawana. Thank you.
Thank you, Ms. Johnson. Mr. Jones?
Thank you. I heard repeatedly a reference by counsel to doctors, the respondent's status as technically on call, which I believe is indicated or used to minimize the fact that he was on call. It's not a technical matter. The doctor was on call. It's suggested that, well, he had the little app on his phone and he could have toggled off. Well, he had the opportunity to toggle off when he decided to drink, and he didn't do that. He had the opportunity to toggle off when he was drinking. He didn't do that. He had the opportunity to do that before he got in his car, but he didn't do that. So to suggest that he, of course, would have, if he got a phone call during that period, escapes or minimizes the fact that he had shown that he didn't do it. More importantly, on top of all that, he was impaired at the time. So to suggest that he would have, of course, toggled off as a rational individual would have done ignores the fact that he was impaired. And that is the significant issue. So I believe that the appropriate level of discipline should include the uniform standards as discussed in my opening remarks. Thank you.
Thank you. Did any of the panel members require clarification of any of counsel's arguments? Go ahead and announce your name before you ask your question.
Howard Kraus. I'm interested to know if Dr. Tawana wishes to address the board, or if he may be available to receive questions from the board.
We will get to that. First, let's focus on counsel's argument and whether you have any questions about the arguments that need clarification. Anything? If,
Well, actually, I had a question.
okay, state your name, please.
Brenda Sutton Wills. My question had to do with the assertion to the officer that he was in fact on call when he was stopped and that he had the power to save lives and the lives of the officer.
What was it?
And
Who
so,
is this question addressed to?
to counsel. So your argument
Counsel
that,
for respondent.
yes.
Thank you.
So your argument that he would have toggled off while he's in fact affirmatively asserting to the officer that he is on call, how do you address that?
Well, I think it's most clearly addressed in Dr. Chawana's testimony himself, so that way I'm not speculating, but instead using his own words. And at the administrative hearing, he testified as to the fact that he is originally not actually from the United States, and that in his home country, that's actually something that they can use culturally, or something that they have done culturally in terms of asserting the profession and essentially having it be waived off. He, of course, then admitted that this was a mistake, not only in the sense that he was relying on a previously exercised culture, but more importantly that he shouldn't have tried to assert anything. And then he almost immediately followed it up with taking responsibility, admitting to the officer the situation, becoming, as deemed by the officer, cooperative and fully answering the officer's questions, complying with the blood alcohol test, complying with the sobriety tests as well. There was an assertion, obviously, at the beginning. It's something that not only is in the police report, but Dr. Chawana testified to at the hearing and at the investigation itself, that this was a obviously poor decision based on a culture that he had previously known or that he had witnessed growing up, and has almost immediately been rectified in the situation. And so there's almost a disconnect between the two, trying to essentially get out of the situation initially before immediately accepting responsibility, and making sure that doesn't correlate to the idea that he would in fact actually be on call, or that he would in fact take the calls while on call. And so the two, using one statement to the officer versus actually taking the calls and returning to the hospital and treating patients that night, in a lot of ways are separate.
In your assessment of the record, was there a person who knew to be immediately, so if there was a emergency where the doctor needed to be contacted while on call, the time element of him switching to not being on call after the call was made and after he had been drinking, where's the safety measure there for the patients?
And I'll caution counsel to only refer to evidence already in the record.
No problem. It's essentially based on how it was testified to at hearing. It's essentially immediate. So there's the push of the app. The call then immediately goes to the other doctors. You can choose, it looks like, either a doctor individually or all of the other doctors on call that night. It's discussed at the administrative hearing. I'm certainly not going to read all the pages, but it's in the transcript, pages 89 through, it looks like 96. And so it kind of covers there, and that's the testimony not of Dr. Chawana, but of his colleague who was explaining how the app system works and how they at the facility use the on-call. It seems like to toggle to other physicians immediately. So it's ringing on Dr. Chawana's phone. He pushes it forward. It's almost like call forwarding, and immediately starts ringing on either the physician chosen individually, or you can choose, like I said, all the physicians on call that night, and it looks like there were several. And so all of those several have the same app pop up, or the same notification on the app pop up, the same way it would have on Dr. Chawana's phone that night.
Any further questions for counsel?
I have a question for the Deputy Attorney General,
And announce your name.
Christina Lawson.
Thank you.
Is there any other evidence in the record of Dr. Chawana's poor judgment? Your argument seems to be that this incident, well, there is evidence that this incident is poor judgment, but was there other evidence you presented that showed that there was some sort of pattern of poor judgment or a lack of thoughtful decision-making over time?
The only evidence with respect to his exercise of poor judgment is during the course of the events on the day in question, in choosing to drink while on call, in drinking and not toggling off, in choosing to drive while impaired, in asserting to the police officer initially that he hadn't had anything to drink and subsequently saying I had one. And throughout the period of the interaction with the sheriff, even the last word was, "I'm on call, please don't do this to me." So that is basically the parameters of the poor judgment exercise in this case.
Any further questions? All right, did respondent wish to address the board regarding the penalty? Please raise your right hand. Do you swear or affirm that your testimony in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You have to speak up and into the microphone so that everyone here can hear you, including the court reporter who's making a record. State your name.
Jasbir Singh Tawana.
Thank you. And what did you wish to say to the board about the penalty?
Well, first of all, thank you for letting me the opportunity of coming here. And all I want to say is I'm sorry. This was one-time mistake, and I've never had anything prior to this or after this. And I will go by whatever the decision is from the board. Thank you.
You may ask a question, yes, and state your name.
Thank you, Judge Dave Ganadev. Dr. Tawana, I'm still getting somewhat lost on this on-call issue. I think that's the only one which sits on my mind other than your one-time mistake. So explain to me how you can push the call off your colleagues might also be having their own leisure time activities. So what's the understanding here? How do you do this? Does this happen? Not just alcohol, does this happen because of family issues and others between all of you? And so explain to me a little bit more about your on-call, which is the one which is stuck in my mind.
All right. This question could conceivably be calling for testimony that reflects information that does not already appear in the record. I'm going to restrict respondent's answer to only information that is already in the record before the board. And counsel, I'll caution you to monitor that.
Judge,
Yes.
may I comment that my review of the record does reveal this discussion and this information?
Do you have a site?
I'll have to find it again.
That's okay. Was it the pages that Ms. Johnson referred to from the transcript? Which pages, Ms. Johnson?
Well, there's a couple of places. So Dr. Tawana's testimony is not the pages I referred to. I referred to the pages of his colleague who testified as the on-call. And those, his testimony begins on page 81, and it continues touching upon it in various ways through, it looks like, page 96.
That was the testimony of the colleague.
Correct, and I can certainly try to find Dr. Tawana's testimony on the matter as well.
Please do.
Your Honor, it's also the complainant's documents on page 118.
Complainants. Which documents are you referring to?
The complainant's exhibits, volume 1, exhibits 1 through 14, page 118 of that document. This was in reference to a telephone interview with Dr. Tawana's
Johnson, have you found anything else in the transcript?
No, sorry, Your Honor.
No, that's okay. I can't allow respondent to go beyond what's in the transcript and in the exhibits that were already submitted and are part of the record.
Judge, I'm not asking him to go beyond. I want to hear from him. I'm not asking him to go beyond what's in the transcript. I want to hear from him. He's in front of the board, so that's all I'm asking.
He is in front of the board, but he's not here to give evidence. The evidence is already closed.
Yes, sir.
He is here only to address under the statute the penalty. And that's what he has addressed, and you may ask questions about that. I'm not going to allow anything beyond what's already in the record. And the record is pages 81 through 96 of the transcript and page 118 of complainant's exhibit. And that's it.
I'm good with it. It's okay. Thank you.
Thank you. Anything else? All right, then this matter is submitted. The record is closed. Thank you all very much.
Thank you.
The panel will now go in.
To the Medical Board of California, Panel B, meeting of 4/26/17. My name is Michelle Bolot. I'll be chairing this meeting along with my colleagues and will be presided over by Judge Cohen.
Good morning. We are now on the record before the Medical Board of California in the matter of the accusation against Amir A. Peruzian, MD. Case number 10-2011-219745. OAH number 2013030328. This matter, which is oral argument regarding the remand to the board following a Court of Appeal decision, bears OAH number 2017040304. This is the time, date, and place set for oral argument. In the notice of hearing for oral argument on this matter, my name is Howard Cohen. I'm an administrative law judge with the Office of Administrative Hearings. I've been assigned to preside over this hearing. First, to ensure that there is a quorum, I'll ask the panel members to identify themselves for the record, starting on my right.
Dave Garner, Dave.
Christina Lawson.
Michelle Bolot.
Howard Kraus.
Brenda Sutton Wells.
Okay, there being a quorum, I'd like to have the appearance of counsel, please.
Good morning, Your Honor, members of the panel. Supervising Deputy Attorney General Matt Davis on behalf of complainant.
Good morning. Respondent is not at the table and no one representing him is present. Is that correct?
That's correct. I know him, but I'm not a lawyer. I just know him. I'm in law. I have heard about the case and all. I just want to bring it up to the court's attention that he's sick.
Okay, we can't, first of all, you're not sworn in, and there was documentation to the effect that he was ill and out of the country and not going to be attending. Is that correct, Mr. Davis?
Well, my understanding is, Your Honor, that late last week, a staff member from the board received a phone call from someone who represented themselves as his brother-in-law and indicated he has a bad back and can't travel from Iran. That's where he is currently located and has lived for some time. The notice of hearing was served on him at his address of record at what we believe to be his brother-in-law's address and via email in Iran. During the prior litigation in this case, the Superior Court said it was appropriate to serve him by email because a lot of the mail service was coming back non-deliverable in a foreign country. We also know that he was on notice of the hearing because he cited this very hearing in one of his most recent filings in Superior Court trying to overturn this remand. He's not here. He's been put on notice. We've received no motion for a continuance of this, so I think we're on solid ground moving forward.
Okay, let's do that. respondent not being present, I will allow you, Mr. Davis, 15 minutes for argument.
Thank you. The administrative hearing in this matter occurred between December 9th and 13th, 2013. Subsequent to that, a proposed decision was issued revoking Dr. Peruzian's license, which was adopted by the board. That decision was based on allegations of dishonest and corrupt acts and conviction of a crime substantially related, and that was based on his engagement in disability insurance fraud. What happened essentially was he was working in 2006 to 2007, he was working for children's specialists in San Diego, California, as a physician. He was covered under a group disability policy, and he had also purchased a couple of individual disability insurance policies. On about August 1st, 2006, he took a medical leave of absence from CSSD, that's Children's Specialists of San Diego, due to difficulties associated with depression. He filed a claim under his group policy with CSSD, and he also filed claims under his individual policies. On or about October 16th, 2006, he returned to work part-time, and his disability payments were adjusted based on a partial disability analysis at that time. In June of 2007, he requested a year-long sabbatical from children's specialists, which was denied due to workload, and so he indicated he would be taking a 3-month medical leave of absence based on his depression.
Mr. Davis, I know I didn't say it on the record in this hearing. You were present during the first hearing, and you understand you can only raise matters that were addressed below and that are in the record that appears before the panel.
Right. This is all matters that are in the record.
I just wanted to clarify that for the record, and the court reporter is making a transcript of this, so I want that to be very
Yes,
clear.
this is all, and I can cite you the reporter's transcript if you'd like, or the exhibit numbers.
If the panel members have any questions regarding what you're saying now, and they'll have an opportunity to ask you, and at that time you may cite the record.
Thank you. So, backing up, he began his 3-month medical leave of absence on July 1st, 2007. Well, unbeknownst to the insurance carriers and his employers, he had submitted an application to Kaiser in December of 2006, so approximately 6 months prior. And he'd signed an agreement as an associate physician on May 25th, 2007. And he had an effective date of work of July 16th, 2007. So essentially what happened was he's receiving disability benefits based on a disability he's alleging through children's specialist and working at Kaiser at the same time. Well, a patient's relative recognized him at Kaiser, and the scheme unraveled. And then he started making misrepresentations about what was going on. First of all, he never disclosed to his treating physician, who was authorizing the disabilities, that he'd taken a job at Kaiser. He never told the insurance adjusters that he was working at Kaiser. He actually made false statements regarding his claim to the insurance adjusters. He admitted he knew all the statements he made regarding working at the same time as receiving disability payments were false at the time he made them. He testified to that at hearing. Ultimately, a criminal case was filed against him for insurance fraud. That case was ultimately settled for a misdemeanor plea of Penal Code Section 148A, which is resisting arrest or obstruction of an officer in the performance of their duties. And that was based on him not cooperating with the Division of Insurance investigation and lying to their investigator. That was the ultimate conviction in this case. The case went to hearing, and as I said, the proposed decision recommended revocation of his license, which this board adopted. Subsequently, Dr. Peruzian, through counsel, filed a petition for writ of mandate in Los Angeles Superior Court. That petition was denied. He then went to the California Court of Appeals, and that, after he filed in August of 2015, the Court of Appeal issued an order requesting briefing on the matter, and in addition, at that point, on September 1st, 2015, ordered that his revocation be stayed. So the board's action was stayed by the Court of Appeals as of September 1st, 2015, and these numbers are going to become important when we talk about what appropriate penalty is now. On June 29th, 2016, the Court of Appeal issued its decision overturning the denial of his petition for writ of mandate, remanding the case to the Los Angeles Superior Court with instructions for them to remand the case back to the medical board to recommend discipline consistent with the Court of Appeal's decision. Now, the Court of Appeal had, this case on its face, this level of dishonesty, I think rightly warranted revocation. However, there were a couple of issues that the Court of Appeal noted in finding that that was an abuse of discretion. They noted that it was over a discrete period of time in 2007 when he was engaging in this fraud, that he suffered from depression while engaging in this fraud. They also noted that the amount of money was not as large as other cases. For example, the Wyndham case, which is a published case that this board issued a disciplinary order against a doctor who'd engaged in tax evasion. His tax evasion was about $60,000. Perusian's amount, I'm not sure of it, but it was significantly less than that. And in the Wyndham case, this board put Dr. Wyndham on probation for 3 years. So the Court of Appeal looked at that and said, look, this guy took more money than this guy, and you're revoking this guy, which I don't necessarily agree with, but this is what the court found. They also found that, and this was, in my mind, in reading the opinion, I thought this was significant. They viewed the board's revocation of his license as what they claimed making up for the lacking criminal penalty. Because he did get a good deal in the criminal case based on the conduct. Unfortunately, the ALJ at the administrative hearing made a comment on the record to the effect of, you got the best deal of any man to walk the streets of San Diego since 1900. So the Court of Appeal took that and interpreted it as the ALJ was making up for what he viewed as lacking in the criminal sentence. And we can't punish doctors under the administrative disciplinary scheme we operate under here. So the Court of Appeal said this appears to be punishment and you can't do that. Hence, they remanded it. So what we're left with is a remand from the Superior Court for this board to take action consistent with that opinion. So they didn't specify, but what they're saying in between the lines, in my view, is that you can't revoke him, but you can put him on probation. So what we would recommend, based on the Court of Appeals decision and the facts of this case, is revocation stayed, 5 years probation, a professionalisms program, a psychiatric evaluation, billing monitoring, solo practice prohibition, and all standard terms and conditions. And I'm happy to entertain any questions if there are any.
All right. Any questions from the panel members for council? Go ahead.
I have a question. Why the solo practice prohibition?
And announce your name, please.
Brenda Sutton-Wells.
I think the solo practice prohibition is recommended because he engaged in he was subversive in both places where he's practiced. And as we know, dishonesty can't be compartmentalized, as Wyndham said. When you're dishonest in one area, the odds are that you may become dishonest in other areas, including the practice of medicine. He was both dishonest at Children's Services and he was dishonest at Kaiser. We don't know if it involved patient care at this. We're limited to the insurance fraud portion, but we would want somebody, taking a look at his practice and not allowing him to practice unfettered until this board's satisfied that he can operate within the bounds of what's required of him in terms of honesty.
Is there a reason a records monitor wouldn't resolve that concern?
That's an option. No, I don't think there's any particular reason why a medical record monitor wouldn't serve that same function.
Any other questions by any of the panelists?
Your Honor,
Yes.
Howard Krause. It would appear that because of true disability, that he's likely been unable to practice for a period of time. Should his probation also include assessment or PACE program before re-entering?
That would be something, I can say that he's been in Iran for some time, and it's my understanding that he may be practicing there, but we don't know. And he has been out of the country for some time, so a PACE class to ensure that his clinical skills are sharp may not be a bad idea as well.
Any further questions?
Comment?
I'm sorry, you don't have standing in this hearing. You're not an attorney, you don't legally represent respondent, and you are not respondent, so no, I'm sorry. Any other questions by the panel members for Mr. Davis?
Just a comment. You can just look at the record, from the Court of Appeals record.
Sir, you cannot make a comment. All right, there being no further questions then for the Supervising Deputy Attorney General, the matter is closed and submitted, and we will go into closed session.
Thank you.